fact, on the part of the respondent, Chief Justice Corona, is the failure to correct all the misleading and inaccurate disclosures of the spokesperson, including the misrepresentation that the voting was 9-4 when in fact it was 7-6, including the misrepresentation that as of November 15 and even as of November 18, the TRO was not yet effective.
This is on the basis of your examination or reading of the dissenting opinion of the Honorable Justice Sereno.
The Honorable Justice Sereno and Justice Carpio. Yes,
No,
sir.
I'm
Yes,
not,
sir.
I'm limiting myself only to Justice
Yes, sir.
Sereno's dissenting.
Yes,
Anything
sir.
more? Something that is substantial.
These are very substantial,
Yes, Your Honor.
especially the changing of the draft from the drafter of the November 22, the alteration of the draft of the November 22 resolution from the statement that there was no compliance of the conditions of the conditional TRO to there was substantial compliance with the conditions of
Now,
the conditional TRO.
Are you now?
Yes, sir.
My understanding based from your answer,
Just to clarify, who was the drafter? Madam Secretary.
It was assigned, Your Honor, to Justice Velasco by Chief Justice
And
Corona.
he drafted the resolution.
He drafted the November 22 resolution.
And
Yes,
there
Your
were there were changes.
Yes, Your Honor.
may I now proceed, Your Honor?
Proceed,
Thank you, Your Honor. Now, based on your answer now, I gather the impression that all the matters you stated a while ago came from your perusal or reading of Justice Sereno's dissenting opinion.
Yes, sir.
Yes, sir. So much so that they are not from your own personal knowledge.
Yes, sir. I'm not a member of the court.
In other words, what you have told us, insofar as you are concerned, are merely purely hearsay because they do not come from your own personal knowledge.
Objection,
Am I
Mr. President.
What is the ground for-
The
Just a
question
minute,
is
wow.
misleading.
What
The dissenting opinion is a matter of judicial notice. In fact, we have marked this dissenting opinion as an exhibit for the prosecution.
That is not the subject of the examination, Your Honor.
The question...
Go ahead, please. I'm sorry.
The question, Mr. President, the question is leading in form, but misleading in substance. Because the question is, all that you have said or what you have testified to is hearsay, which is not so. It's misleading because as he testified, and as the question called for, she was reading from the dissenting opinion, which, as I said, is a matter of judicial notice.
That is precisely the basis of my question, Your Honor. What the witness told the court is merely what she gathered from the dissenting opinion and not from her own personal knowledge.
The Secretary may answer.
Secretary,
Go ahead.
Based on an official document
all right.
officially released to the parties.
I would like to clarify the reason for this ruling so that the people will not misunderstand, because we are dealing with technical rules with rules of evidence. The Secretary indeed read the dissenting opinion, and by reading that dissenting opinion, he has knowledge of the facts stated in that dissenting opinion. But to the extent of the truth or falsity of what has been stated in that dissenting opinion, if there is any falsehood, is hearsay. Because as far as the witness is concerned, because she is not present in the proceedings of the Supreme Court. So that's why I allowed the Secretary to answer.
Mr. President, I only objected to the use of the word hearsay.
Yes.
I objected to it because...
Sa Tagalog, hindi galing sa inyong sariling kaalaman.
Hindi.
Because you said hearsay, so I'm elucidating on that.
No, I just objected. Tumutol po ako, Ginoong Pangulo, dun sa paggamit ng kagalang-galang na pagtanggol ng salitang hearsay, sapagkat ang hearsay po eh may kahulugan sa ngayon sa ating rules of evidence. Hindi ako tinutukoy.
Naiintindihan po ng presiding officer yan.
Okay.
Pero ang ating testigo dito ay hindi pangkaraniwang testigo. Siya ay tanyag na abogado. Alam niya ang ibig sabihin ng hearsay at intelihenteng testigo ang ating kalihim. Pwede niyang sagutin yun. Kaya ang ruling ng presiding officer, she must answer.
Tinatago po namin yon, Ginoong Pangulo.
May we be allowed to proceed, Your Honor?
Proceed.
All right. Now, you also made us understand that the basis of the information you revealed to this honorable court on the issue of alleged infirmity or irregularity is solely on the basis of the dissenting opinion of Justice Sereno. Am I right?
On the basis of the dissenting opinions, not just of Justice Sereno, but of Justice Carpio, sir.
You are referring to the dissenting opinion of Justice Carpio?
Yes, sir.
I have read the dissenting opinion of Justice Carpio, and Justice Carpio never mentioned about the dates you had mentioned. For instance, the schedule or argument, the deliberation made, the voting, and so on. His dissent is solely on the basis of the character of the conditions imposed. According to him, since they were not complied with, then the restraining order should not be made effective or enforceable. Am I not right?
Yes.
All right. There is nothing in his dissenting opinion which deals with the matters dealt with in the dissenting opinion of Justice Sereno, as you have narrated to this court.
For the defense, I think, to be fair to the witness, if you have the dissenting opinion of Justice Carpio, this is an effort to confront the witness, then I think it's only fair that the document, as a basis of confrontation, must be shown to her.
I would have done that, Your Honor, but I was given the impression that the Honorable Secretary of Justice had them in her possession, Your Honor.
I have a copy, Your Honor.
All right.
She had
The Secretary may answer.
Will you kindly indicate that particular portion in the dissenting opinion of the Honorable Justice Carpio dealing with the dates you mentioned, the irregularity and the infirmity, which was the subject of his dissent?
Not on
Witness examining.
Yes, sir. Not on those matters directly, because as you correctly stated, sir, his dissenting opinion
Is
primarily
the-
delved on the character of the TRO.
On the-
But there is also a portion towards the end of his dissenting opinion about the issuance of the TRO that was issued or released to the petitioners before 6 o'clock in the evening of November 15, even before petitioners' compliance with the first two conditions.
So there is nothing mentioned there about the alleged deliberation, the lack of oral argument, the lack of notice, and so on.
It's not in the dissent of
I
Justice
am very
Carpio.
sure that you must have also gone over the dissenting opinion of the Honorable Sinuisa. Reyes, the other dissenter. You must have gone over his dissenting opinion also.
For the November, is it the December 13?
With respect to the grant of the restraining order,
Yes,
which
sir.
was the subject of, and
Yes.
I have examined it. Will you kindly go over it and tell us in what particular portion of that dissenting opinion had the dates, the lack of notice, and the irregularities you mentioned before the court were incorporated? Because I do not find any for your information, Madam Secretary.
There is none, there is none, sir, because the dissenting opinion of Justice Reyes is the dissenting opinion of November 15, or the dissenting opinion to the TRO itself, where the very issue on the legal status or efficacy was not yet there, because
So
we
the-
don't have the facts yet,
So
the
the
inside facts.
I'm sorry.
Yes, sir.
So the basis of his dissent is that if the court acts on the application for the restraining order, one way or the other, it will render moot and academic the principal issue in this case. That is the substance of his dissent.
Yes, sir.
All right, thank you. Now, if that is so, why have you laid too much an emphasis on the dissenting opinion of the Honorable Justice Sereno? Will you kindly tell the Honorable Court the reason for your giving too much emphasis and why you highly gravitate on that dissenting opinion?
I'll gladly do that, sir. I have given importance, or I'm highlighting the dissenting opinion of Justice Sereno, not because of the discussion there on the merits of his dissent to the grant of the TRO. It's not actually about being the dissenting opinion, or it's not the dissenting opinion per se, but on the various disclosures or revelations that she had made, which gave us or give us the picture of the irregularities that were committed within the court insofar as the issuance of the TRO as well as the interpretation of the legal status or effect of the TRO.
Thank you. And these matters are now pending consideration before the Honorable Supreme Court.
The main petition,
Correct.
sir, yes.
Together with the alleged errors or irregularities attendant to the grant of the restraining order. Am I right?
I'm not sure if it's still being discussed or being deliberated upon by the Supreme Court, the alleged irregularities.
I'm telling you now that it is one of the issues involved in that case, which, and it is because of the citation against the Honorable Secretary of Justice for contempt for having violated the order of the Honorable Supreme Court in connection with the grant of a restraining order. Am I not correct?
In a sense, sir, yes, you're correct.
In what sense am I wrong?
Well, because if you are referring, sir, to my compliance to the show cause order, and the grounds I cited there is, number one, the lack of notice, and number two, it's a conditional TRO. Then the irregularities within the Supreme Court on the interpretation of the legal status, well, would not really have much bearing on the issue of my non-compliance. Because in the first place, when I submitted my compliance of the show cause order, I wasn't aware yet of those irregularities.
Correct.
Until I saw the dissenting opinion,
That is
December
correct.
13, of Justice Sereno.
And it is, and that was why I asked you the question whether, without having come across with the dissenting opinion of Justice Sereno, you would not have known all these irregularities that you mentioned in your direct examination.
Yes, sir.
All right, thank you. Now, apparently, you gave us the impression, and this honorable court, that permit the language, that you swallowed hook, line, and sinker the truth of what is alleged or incorporated in that dissenting opinion. Am I right or I'm wrong?
I'm giving it credence, serious credence, because it was never disputed or denied by any other member of the court.
But it remains to be a dissenting opinion up to now, unless modified or reversed by the Supreme Court in the final adjudication of the case.
It is a dissenting opinion on the very issue at hand, which is the issuance of the TRO or the propriety of the TRO. But it is not an ordinary dissenting opinion because it dwells on those other matters.
And it almost exempts you from criminal liability for being declared or being asked to show cause. Why should not be punished for contempt?
That is your interpretation, sir.
Yes, it saves you from the trouble of being made liable for having allegedly disobeyed the order of the Honorable Supreme Court, because there is Velasco and also the rejoinder that she made for not having been able to answer the issues raised in the dissenting opinion of Justice
Rejoinder
Sereno.
of whom?
Pardon, Your Honor.
Rejoinder of whom?
By Justice Velasco, Your Honor, the ponente of the case. Now, may I be permitted to go another? In that case, Your Honor, I will move, much to my regret, for the striking out of the entirety of the testimony of the witness on the ground that the same is hearsay, insofar as the accuracy, the truth, and